Hello there, this video goes out to a couple of my viewers, Sade and Derek, who are both studying equity and trust at the moment. And I think that charities is a really good subject to pick if you do have an option when it comes down to an exam or a piece of coursework. The reason for this is that charities is a really self-contained area. In other words, once you know the relevant sections of the Charities Act 2011 and some of the relevant case law as well, you're pretty much there. There's not really much cross-pollination with other areas of equity and trusts. Nevertheless, you shouldn't be lulled into a false sense of security in thinking that charities, because they do such great work, is an easy area of the law. Remember that charities lie in that sort of strange area between the private sector and the public sector in terms of their role and the job that they carry out within society. This means that it's really important that charities are accountable for the donations that they receive. And so we'll look at how the law regulates this area, and also at the end take a quick look at the Charity Commission, who are in charge of this particular area of the law. Right, with that in mind, let's get started. Let's start this discussion by having a think about charities in general. And we can firstly say that charitable trusts must be exclusively charitable. In the case of Blair and Duncan from 1902, the phrase charitable or other purposes was used. But clearly this is not going to work. If I set up a charity and said that it was for charitable or other purposes, well, those other purposes might just be my bank account. Nevertheless, the courts do look to the overall intention of a charitable trust, and if it is seen as being charitable, then it will be allowed, and this was seen in the case of Guild and IRC 1992. And this is probably quite a good opportunity to say that the courts in general will take a very broad view when it comes to charities. They're aware of the good work that they do, and they don't really want to get in the way of positive work and positive contributions to the community. So whenever you're answering a question in this area, you do need to take into account that judges are going to take a very general view, but obviously if a charity is not working for charitable purposes, then that won't be allowed to stand. Furthermore, there's not really any politics allowed in charities, and this is seen as an attempt to change the law. So in National Anti-Vivisection Society and IRC 1940, we have a charitable trust that was set up and tried to change the law in relation to animal testing. This came before the courts, and because the aim of the charity was political in trying to change the law, this was not allowed to stand. However, again, we do have to remember that the courts will take a very broad view of this. We can think about charities like the RSPCA, who I put down there, maybe some of the environmental charities as well, who as part of their overall charity work do seek to change the law so that it's more positive for, say, animals or the environment. And so the courts will take that broad approach once again. So a little bit of background to charities as well. The law relating to charities really goes back as far as 1530, and there's the famous Statute of Elizabeth I from 1601 as well. But really, in the modern era, the main case that we want to look at is the case of Pemsel in 1891, where Lord Macnaghten said that there were four key aims in relation to charities. So we have relief of poverty, advancement of education, advancement of religion, and then the fourth general other purposes beneficial to the community. And those definitions that Lord Macnaghten gave still stay with us very much to this day in the form of the Charities Act 2011. But what we'll see is that the fourth category, other purposes, has been fleshed out a little bit. And so overall now there are sort of 12 purposes that we'll be going through. So when it comes to answering in particular a problem question, but perhaps also an essay question as well, what you need to be keeping within the back of your mind in relation to any particular charity is whether it meets these two criteria. Firstly, there has to be a charitable purpose under Section 3.1 of the Charities Act 2011. And secondly, there has to be a public benefit under Section 4 of the Charities Act 2011. And importantly, Section 4 does make reference to the old case law. So that's something that we're going to look at. And the way that we're going to do this is by going through the 12 different charitable purposes under section 3.1. And for each of those 12 purposes, we're going to try and look at the public benefit alongside that. So let's dive into that straight away. The first paragraph that we're going to be looking at is section 3.1a, that deals with the prevention or relief of poverty. And the first thing to say is that poverty is given a very general definition. If we had tried to apply, say, a certain figure and say that if you earned less than £15,000 a year, then you are officially poor, that doesn't really take into account a number of factors, such as where you live in the country, whether you have a job, how many children a particular person has, and it's basically a complete minefield. So we stick with this general definition, and as long as people fall within that, then they will be able to benefit from the charity under charities law. So my favourite definition comes from Coulter's Trust in 1951, and this uses the idea of going short. So we're not just talking about people who are completely destitute and are on the streets, and we're not talking about people who can afford the basic amenities and can get through life. But anyone who falls under that criteria of being able to afford the basic amenities needed for life in the UK, that will satisfy the definition of poverty, certainly under Coulter's Will Trust. Secondly, there has to be a genuine charitable intention, and this relates to the main case in this area, which is Dingle and Turner. And the idea in Dingle and Turner was that there was a connection between the charity and the people receiving the charitable funds, and whether this should be allowed, especially in relation to the idea of a public benefit. And the court said that as long as there is a genuine charitable intention, then it doesn't matter if there is a connection between the charity and the people receiving the charitable funds. And this links into the third point, which is there's no public benefit requirement. So for all of the others, there does have to be some sort of public benefit. But if you can imagine, if you were setting up a charity to, say, help homeless people who were living out on the streets in Manchester, that's a relatively small selection of people. And so even though you are doing good charitable work, and there is, as per Dingle and Turner, a genuine charitable intention, there isn't a public benefit there in a wider sense. But obviously it would be unfair to stop that charity being set up, and so that's why for the prevention or relief of poverty, there is no public benefit requirement. So just because you're a charity doesn't mean that you aren't allowed to charge for services, and this is obviously something that many people aren't aware of. But a lot of charities that run on a day-to-day basis and are particularly big charities will often have staff who are paid for their time. Not everyone is volunteering. And so charities are allowed to charge for services under RECOTTM. They can charge rent if they provide accommodation. And they can also trade as well, which is from the ICLR, the Law Reports case from 1972, which is an interesting case which law students should probably have a quick look at. As mentioned previously, the idea of there being a public benefit and the idea in Dingle and Turner means that charities can actually be set up to help poor relatives. And this was seen in the case of Rhys Scarisbrick, 1951. So moving on to the next paragraph, we have the advancement of education, and education is given a very broad definition. So obviously it includes things like schools and universities, and it might be helping by providing sort of teaching facilities or books, things like that. But it could also mean just providing the desks and chairs that go into a classroom, or perhaps even providing sports equipment for a school. Also, it will include research, and this was seen by the judgment of Justice Slade in McGovern and Attorney General 1982. For this, we need a definition of research, and so research can be charitable if the subject matter is considered to be worthy of study, the knowledge will be made publicly available, and there is a benefit for the public more widely. So one of the cases in this area is Rhys Shaw, 1958, and this concerned the playwright George Bernard Shaw, who wanted to set up a charitable trust to basically invent a new language. And this was being seen as too politically motivated by the judges. The reason for this is it was to do with a wider idea of promoting socialism. So that wasn't allowed. Another good example of research is the case of Rhys Hopkins from 1965. And this research looked at the idea about whether Shakespeare actually wrote the works or if they were instead written by Sir Francis Bacon. And spoiler alert, Shakespeare wrote Shakespeare's works. So on the last screen, we talked about the link between sports and the advancement of education. And in the case of IRC and Macmullen, they said that where, say, for example, sports equipment is provided, then in order to meet the idea of it being for the advancement of education, it should be provided to an actual education establishment. In other words, a school or a college or a university. But again, it's important to remember that the courts do take a very broad approach to this. And so in Reed Dupree's deed trust in 1945, money was given to set up a local chess club, which wasn't necessarily linked to an education establishment. So what the courts had to do in this particular instance is, first of all, decide whether chess actually counts as a sport, which they decided that it did, and secondly, whether it has to actually go to an education establishment. And the court said that because chess is really important for developing young people's minds, it can actually be linked to the advancement of education. So moving on to the public benefit, we have to look at the reality of the situation. And this can be a particularly controversial area. A good case to start off with and looking at the reality of the situation is IRC and Educational Grants Association 1967. In this particular case, educational grants were being provided to young people, but they were generally being given in about 80% of the time to employees of a certain company. And so it was seen that, generally speaking, there wasn't actually a public benefit. There was only a benefit to a small section of society. So that in that case, they said that that wasn't actually serving a public benefit in relation to the advancement of education. The wider question that often comes up in the media and is often asked as an essay question in this area is to do with Eton and other private schools. So a lot of those posh schools like Eton are actually registered as charities. And one of the questions is, are these schools actually providing a public benefit? On the one hand, they do tend to do some charity work. They also work with local public schools as well and can offer scholarships to poorer students so that they can come to those schools. But the important thing is that there are huge tax advantages to being registered as a charity, and that's why a lot of institutions decide to register with the Charity Commission. And so we have the question here about whether schools should receive those tax breaks for providing what could be seen as a limited public benefit. Okay, they do some charity work, but is that sufficiently wide enough to actually take advantage of those tax breaks? So that's something for you to think about there. We'll move on to the next paragraph though, which is the advancement of religion. And previously this might just be seen as exclusively to do with Christianity in the UK. Obviously then we have other religions that come in as well, such as Judaism and Islam. And so the definition of religion has got broader over the years. And in the Charities Act 2006, which has now been consolidated in the 2011 Act, the definition of religion now includes polytheism, which could obviously include things like Hinduism, and also religions without a god. And so this raises the question about, well, in 2017, what is actually the definition of religion? And so we can look to some areas. There's not much in the case law about this, but just thinking about it generally, we could say that religion involves a belief in something that is supernatural and also involves, say, a code of conduct about how to live your life. Now, obviously, a number of things could fit into that definition, including, for example, Jedi, which I've put there. But perhaps there would also be a third criteria that the religion has to be sufficiently serious. So, public benefit for the advancement of religion. I guess the important thing to say for this paragraph is that praying doesn't technically count as this. And this was seen in the case of Gilmore and Coates 1949. I think that when we're talking about a public benefit, the benefit itself actually has to be tangible. It has to be something that is seen or can be proven in a court of law. And it doesn't necessarily mean that it has to be particularly useful, But in Thornton and Howe in 1862, there was a rather strange book that was being published about what it's like to be pregnant with the Messiah. And even though that is obviously sort of complete nonsense and was probably sort of a bit questionable in terms of how useful it was, there was actually a tangible benefit in terms of the book actually being published. So that was allowed to stand. Again, the court's taking a very broad view and trying to be sensitive to religions. Section 3.1d is to do with health and saving lives. Obviously, that includes funding for medical research, so you can think of charities like Cancer Research UK. But it also includes prevention and relief of sickness, disease, or human suffering under the 2011 Act. And that's very broad language once again. Human suffering could be taken to mean almost anything. It could be mental suffering, physical suffering, and could even leak into things like people who are sort of suffering from torture. So saving lives, on the other hand, which is the other part of Section 3.1d, this could include services such as St John Ambulance, and also that case of Ree David from 1889 was to do with lifeboats and the RNLI. 3.1e is citizenship and community development. When this first came in 2006, it was to do with the idea that charities are generally taking over the work of the public sector in terms of helping people out. And so they could actually be used to help promote the community, promote citizenship. And this was followed up and retained in the 2011 Act under the Conservative Lib Dem coalition, especially under David Cameron's idea of the big society. And so charities in this area might include things that help towards community regeneration, so providing for restoration of local monuments, things like that. Volunteering within the local community as well, I guess, might count. And also the advancement of things like cultural cohesion. We often hear in the news now about how communities are being sort of torn apart, and we have people living in different areas who don't really communicate with each other. So you might want to set up a charity that sort of alleviates that to some extent. I guess the question about that comes back to the idea of how tangible a public benefit is something like cultural cohesion. It's not something that you could sort of prove has improved in the last 5 years since your charity has actually been set up. And it's not like Thornton and Howe, where there was actually a book produced at the end of it. So the question about a tangible public benefit does really surround Section 3.1e in general. Section 3.1f is to do with arts, culture, heritage and science. And I guess the important question to raise here is what actually counts as art? Does the art have to be particularly good? Can it be sort of bad art? Especially the same thing applies to culture as well. What is considered as being beneficial for the culture? And I think the problem that we have with Section 3.1f is that we're almost turning judges into art critics, deciding what actually is good art and what's bad art. So with that in mind, I'm obviously sort of hoping to set up my own art foundation, and you can see my first attempt there, which I'm sure you'll agree is pretty fantastic and definitely deserving of charity. So put your bids in the comments below. Section 3.1g is to do with amateur sport. The focus here is on the word amateur. If you're playing an amateur sport, then that means that you're not getting paid for doing so. So obviously, like Manchester United couldn't be set up as a charity because their players are getting paid for doing so. Again, this comes back to the idea of what actually is a sport as well. So we already talked about how Ree Dupree's Deed Trust talked about chess being a sport. And I've also seen recent decisions by the Charity Commission that suggest things like bridge, the card games as a sport. So a very broad definition of what sport is, and as long as you're not getting paid for it, you can set it up as a charitable trust. Section 3.1h is to do with human rights, racial harmony. There's another couple of categories that fall into that within the section of the Charities Act 2011. I guess the main question here, which is slightly controversial, is does this not really count as politics? We talked about the anti-vivisection case from 1940 earlier on and said that charities should not be political. But if they are promoting human rights or racial harmony, is that not really a political purpose? I think back to the case of Strakosch in 1949, which was to do with the idea of improving relations between the Boers and the British after the Boer War. And at the time, that was said that that could not be a charity because it was political. But realistically, you could see that falling within Section 31H nowadays. Again, we have the idea of there being no real tangible public benefit to this either. It's not like you can show that human rights have improved because of your charity work, or that racial harmony has increased because of the work that your charity has done. Section 31I is to do with the environment. This could be the local environment near where you live, or it could be the global environment in terms of things like global warming, etc. I think that the idea of the environment doesn't have to just be restricted to climate change as well. So it might be that your charity wants to protect a certain species of animal, and we saw that with badgers recently, or particular plants as well. So environment has a very broad definition. Section 31J is relief of those in need. Arguably, this really sort of falls under Section 31A, because you could say, well, it's the relief of poverty almost. It's the same sort of criteria that we're using. However, I think it goes a bit further than that, because it's not reliant on the people that you're helping being poor per se. So there might be, say, elderly people who are very rich, but still need advice and assistance because they're perhaps struggling at home. One of the main ones that you think about is when elderly people are lonely and they have volunteers who will call up those people just for someone to talk to. And so the charities that do that are helping them irregardless of their wealth. So that could be seen as advice or assistance, falling under Section 31J. K is to do with animal welfare. The courts take a generous view of this area, as was seen in the case of Moss 1949. And I think within the context of the UK, this is not surprising whatsoever. Britain is often regarded worldwide as being the sort of most animal-friendly environment there is. There's a huge amount of animal welfare legislation already in place. And so it's not surprising that this is a criteria for charity on its own. Nevertheless, as we mentioned earlier, the charities still cannot be political or seek a change in the law. We've already talked about the anti-vivisection case from 1940, but I think it's important to say that even after the original act was passed in 2006 and before it was consolidated in 2011, this idea about animal charities not being political or seeking to change the law still stands. And so in the case of Hanshet Stanford and Attorney General, this was all to do with animals who were forced to perform in circuses and things like that. And because they were seeking to change the law in this area, once again they were being seen as political and therefore not a charity. The final and 12th category, yes, we're actually getting there. Army, police, fire and ambulance. And the main question here is, well, isn't this really just the government's job to actually provide for the army, the police, fire, ambulance services? One of the areas where this came up was Wokingham Fire Brigade trusts in 1951. The aim here was to help a voluntary fire service, but we don't really have those anymore. We expect the government to provide for the local police or the local ambulance service or the local firefighters. I guess the other question in relation to the army is, would the courts actually allow a charity, someone who's actually a registered charitable trust, to procure weapons for the army or riot gear for the police? Is that something that we actually want charities to be doing? So that's a little bit controversial. I think we can get round this sort of strange category a little bit by using the idea that these charities should be promoting efficiency in these services. So say, for example, the local fire station or the local police station has a gym. If a charity wanted to provide extra gym equipment, then that's obviously going to be helping the local police force or the local firefighters to be able to get fitter and therefore do their jobs better. So that idea about promoting efficiency is probably the best way to think about those sections of charities under 31L. So a final comment just before we finish is to say that charities and the decisions in relation to what is a charity, what isn't a charity, fall under a non-governmental organisation called the Charity Commission. So as well as deciding on charitable purposes, if you run a charity, then your accounts go through the Charity Commission. You can do that online. And the Charity Commission often produce interesting reports on where there is mismanagement in relation to charities. So one of the things I talked about in the introduction is that where people are donating money to a charity, they want to be making sure that it does go to a good cause. Now that's relatively obvious, but obviously there are going to be some people who will set up a charity and try and sort of either take the money for themselves or not apply the funds in a correct way. And so it's the Charity Commission's job to actually investigate those types of issues. If you apply to be a charity and the Charity Commission says actually you don't fall under any of those 12 categories or you're not showing a public benefit under Section 4, then you can appeal that decision to the General Regulatory Chamber, and it goes from there up to the High Court and into the court system in general. Thank you very much for tuning in and watching this video on the law in relation to charities. I think there's a couple of things to bear in mind if you are going to be answering questions on this subject. Firstly, if it's a problem question, you're going to be wanting to look out for those two essential ingredients. In other words, is there a charitable purpose under Section 3.1? And secondly, is there a public benefit that is tangible in some way? However, I've found in my experience that charities is more likely to come up as an essay question. And so you're going to be wanting to think about some of those key issues that come up and we discussed in relation to charities law. How do we think about a public benefit? Should it be so broadly interpreted? Does there have to be a tangible public benefit? Or is it right that there are some areas where that's much more difficult to prove? Should some of those rich public schools be allowed to be considered as charities? Be interesting to hear your thoughts on that, so maybe leave those in the comments below. Now, if you are answering the question on charities as well, the other important area that you'll need to consider is the see, pray doctrine. And that's something that I'll be covering in my next video. So make sure that you subscribe to this channel so that you see that when it appears. Also, if you enjoyed this video, remember to leave it a like. If you've got any questions, then leave those in the comments below. Thanks very much for watching. Bye.